say welcome to our Spring 2024 Data Protection Update webinar. You'll notice today it's just Rachel and me, so we have no Grant today. He is on sabbatical enjoying the sunshine, but we will be welcoming him back in the autumn. We also have a record sign up for today's event. We have over 400 people, which is fantastic. I don't know if those two things are related, but we will do our best to deliver you some insightful updates and content over the next 40 minutes or so. So this has been quite a strange one in that we are well used to draft bills and new guidance dropping the day before we do these webinars, and we have to spend the day before writing new bits of content. I've never before been sitting with Twitter open, another window, trying to work out what on earth is happening to legislation as we actually go live. But we will try and bring you as up-to-date content as we can over the next wee while. But given the election announcement, we've had to make some tweaks to what we're going to talk about or what we tell you, because some of that may now be redundant. In terms of what we're going to cover, so Rachel's going to kick off today. She's going to cover international updates, so looking at international transfers and what's going on around the world. She's also going to talk a bit about cookies. I will then do a legislation update and talk about children's data and online services. I'll also be talking about biometric technology and some recent cases and guidance on that. And then Rachel's going to pick up on some other recent cases, and I'm then going to finish up with a roundup of some new developments in and around cyber and some guidance and consultation that the government has been carrying out. So I'd say if you have any questions, please do put them in the Q&A and we will pick them up at the end. And without further ado, I will hand over to Rachel, who will kick off on international transfers.
Thank you, Martin. So the first thing that we're going to cover off is transfer risk assessments. Can we move to the next slide? Perfect, thank you. So as of December 2023, the ICO updated its guidance on transfer risk assessments in respect of transfers to the United States specifically. Those of you who've been following our updates for a while will know that transfers to the States have been historically quite difficult with the different Schrems cases. However, we do now have the EU-US data privacy framework and the UK extension to that, which we call the UK-US data bridge. However, you may still find yourself having to complete a transfer risk assessment should the recipient not be certified under those frameworks, and you're instead relying on another Article 46 appropriate safeguard, such as standard contractual clauses in the form of the IDTA or the addendum. However, in order to help you with that TRA process, the ICO has helpfully clarified that it is reasonable and proportionate to rely upon a UK government analysis to help you streamline that TRA process. So currently the Department for Science, Innovation and Technology is the only department to publish an analysis, but it's still a very helpful starting point. So essentially what the department did was it looked at a detailed analysis on the level of protection that the US gives to people in the UK. So it took into account the rule of law, respect for fundamental rights and freedoms, the existence of an effective independent supervisory authority, and also relevant international commitments. So essentially, they concluded that the US data bridge and also other relevant US laws and practices provide an adequate level of protection for UK personal information. They don't undermine the level of protection that people in the UK enjoy under the UK GDPR when that personal information is transferred. So therefore, you can use this DSIT analysis in your own TRA process, whether the personal data that you're transferring is categorized as low, medium, or high harm risk. This also aligns with the EU Commission stance, which essentially set out that the steps taken by the US government to address those issues from the Schrems cases are also helpful in ascertaining comfort that transfers generally to the US can go ahead. So essentially all of this taken together means that while there is the UK-US data bridge and the data privacy framework, even if the transfer that you're looking at doesn't actually fall within those frameworks, you can still take into account various analyses done by governments in order to assess whether transfers to the US are compatible with the rights in the GDPR and the UK GDPR. And as I say, that's mirrored by the EU Commission as well. So moving on to standard contractual clauses, hopefully you'll all have been aware that as of March 2023, it's no longer competent for any UK organisation to rely upon those old EU SCCs. Those organisations that were allowed to do so must have entered into them before 21st of September 2022, and you may remember that there was a grace period to allow you to rely on those before moving on to the IDTA or the addendum. So that deadline has now passed and everyone should now be on the new framework. And as part of that, as we've just discussed in the context of transfer risk assessments, don't also forget to complete your TRA at the same time when you're moving on to the new IDTA or addendum. So what's happening in the rest of the world? So looking to the US, which we often do here, and we all know that their laws have historically always been more heavily focused on sector-specific protection rather than comprehensive regulation in the way that we have the GDPR and the UK GDPR. But as of today, 16 states have passed some sort of privacy law. So what they've been influenced mainly by is the California Consumer Privacy Act, which itself is based on the GDPR. And what we're starting to see now is a lot more consistency in the use of terms such as controllers, processors, and personal data definitions, showing that expanse of the GDPR principles throughout the world. However, as I said earlier, historically, a lot of the laws have been quite sector specific, for example, focusing on healthcare data or consumer data or children's data. And sometimes laws are limited to organisations that meet a certain threshold in terms of turnover or nature of processing. However, more and more of the laws are becoming a lot more comprehensive in their application in the same way as the UK GDPR and the EU GDPR are. Looking to Australia, they've got quite a historic Privacy Act in place at the moment, but over the course of 2024 and 2025, we are expecting them to see them adopt a new act, which again is based a lot on the principles of the GDPR regimes. So, for example, some changes that will then be introduced into Australia are around privacy notices and privacy notification statements, and also the concept of individual consent, which will be mirrored upon the GDPR thresholds for consent. There will also be more robust and more specific data security, retention and destruction obligations. There will be obligations around automated decision technologies. There'll be changes to direct marketing permissions, and also an extension of the current laws to a wider range of organisations. So similar to the US, the previous framework or the current framework within Australia, some parts of it only apply to different sorts of organisations depending on their sector or their size or their nature of processing. So the idea is that the law will become a lot more comprehensive and universal in its application. Looking to the EU, one of the most significant developments has been the passing of the EU AI Act. So that was actually just formally adopted by the Council of the European Union on Tuesday. Organisations will then have up to 2 years to start complying with the majority of its provisions. But what does this mean for data protection? Because obviously AI and data protection are not necessarily one and the same. So essentially, while the new Act is primarily a product safety law for AI systems, focusing on safe technical development, and the GDPR concerns more on the data side, the GDPR is going to essentially fill in some gaps in the AI Act scope. So for example, the idea is that it's very difficult to separate personal data from non-personal data sometimes within AI systems. Therefore, if there's any personal data present in a use of AI, then the GDPR will be invoked. And interestingly as well, the AI principles, or a lot of the principles around compliance, all mirror the same sorts of obligations that we have in GDPR. So the two acts are very complementary and means that there'll be a lot of cross-application between the two acts. So in terms of lawfulness, fairness, transparency, etc., they align over to the AI Act. One interesting piece on that, and it's almost in the same way as we've had the GDPR and its proliferation in similar laws across the world. The AI Act is actually formulated as a treaty, so it's open for other other non-European countries to sign up to. So we'll see. Generally, it'd be interesting to see how widely on a global scale the AI Act, or at least its principles, are followed on a global scale, as we've seen for GDPR and data protection. So I'm also going to cover cookies, and first of all going to look at consent or pay. So this is an interesting mechanism whereby consent or pay models require people to choose between accessing online services without payment, but only if they consent to their personal data being used for personalised advertising. And if they refuse consent, they have to pay to access that service. So firstly, in the context of the UK, you may remember from our last update in December that we covered the ICO's action on cookie banners, where the ICO wrote to 53 businesses about their cookie banner compliance. And at the same time as launching this new call for reviews, the Commissioner has said it will now write to the next 100 most frequented websites in the same way. Therefore, at the moment, it's slightly confusing to know exactly what the ICO's views on cookies are, especially if further guidance comes out of this new call for views in relation to consent or pay. So on this specifically, over March and April, the ICO opened a call for views on the use of consent or pay. And as part of that, the ICO actually also took the opportunity to set out its initial proposed policy approach. So the key point from the ICO was that data protection law doesn't fundamentally prohibit consent or pay. However, in order for organisations to comply, the consent must be freely given, fully informed, as well as being capable of being withdrawn without detriment. So you'll be familiar with the usual conditions around consent. So for example, if there's no free choice, where there's a cookie wall that denies access to the service without consent to personalised adverts, it's likely not to be compliant. However, in helping organisations decide on whether their use of a consent or pay mechanism is compliant, the ICO also took the opportunity to set out some questions that organisations should ask before implementing their mechanism. So for example, power balance. To what extent is there a clear imbalance of power before the service provider and its users? They say that consent for personalised ads is unlikely to be freely given when people have little or no choice about whether to use a service or not. So for example, they say that that could be quite relevant for the public sector. Equivalence, is the ad-funded service and the paid-for service basically the same? What about an appropriate fee? Is the fee appropriate? The ICO also says that consent is unlikely to be freely given when the alternative is an unreasonably high fee. Fees should be set so as to provide people with a realistic choice between the options, therefore to give people an actual demonstrable choice. And then also privacy by design, which follows on from the earlier action that we were speaking about around cookie walls. The ICO again is clear to stress that the choices should be presented fairly and equally. So people should be given clear, understandable information about what the options mean for them and what each one involves. Interestingly, the EU has also been consulting on this recently, so we wanted to just also quickly cover that. So the EDPB has adopted a recent opinion on consent or pay, but it actually comes to a much stricter conclusion than that of the ICO. The EDPB has said essentially where users are offered a binary choice of either consenting to their personal data being processed or paying a fee, in most cases it's not possible to meet the requirements of valid consent. The EDPB really focuses on that idea of detriment, and essentially it's saying that if they choose neither to pay a fee or provide consent to the personal data being processed for behavioural advertising, they really need to be given an actual equivalent alternative, and that's really what they've been focusing on. And so if that's not possible, the EDPB has said that they should be given a free of charge actual equivalent site to go on that shouldn't be any different to the one where a fee has been paid. However, in relation to both, these are just opinions or a call for views. So what we're expecting going forward is actual guidance in the form of regulatory publications from the ICO and the EDPB on this once they have sought views in relation to their current approaches. So I'll now pass over to Martin, who's going to touch on some legislation updates.
Thanks, Rachel. Yeah, so I was going to talk about the Data Protection and Digital Information Bill and give you an update on that. I had to rewrite this bit a wee bit because the bill is currently in the Lords. It went through the committee stage and was due to go to the report stage on the 10th of June. But given the election, that is not going to happen. And looking at the latest list in terms of what's on the list for the wash-up to be finalised before Parliament is prorogued tomorrow, the Data Protection Bill is not on that list. So based on that, I think the Data Protection Bill is unlikely to be passed before the end of the week, and therefore it will fall. And so the changes that were proposed in that are not going to happen, and we'll need to wait until we have a new government to see what, if anything, they propose to do around data protection reform. There's a lot of stuff in that bill which we don't talk about in these sessions around digital information and digital identity, so I would anticipate certainly that would come back. But in terms of whether the proposed changes to UK GDPR will be implemented by any new government, we'll need to just wait and see on that. So if you are interested in where things got to, there's a link there to the latest keying schedules, which will be in slides when we share them after today's event. But I suspect actually there's not much more to say on that. So moving on. The other thing I was going to talk about just now is around online services and children's data. So you will be aware and that the Online Safety Act has now been passed, and a couple of years ago we had from the Information Commissioner the Age Appropriate Design Code that came out in 2021. That applies to providers of online services, and that's a very broad thing. So it covers websites, covers apps, connected devices, and anything that is likely to be accessed by children. And note there that's likely to be accessed, not necessarily that it's aimed at children. So it's a site or a service that children are likely to access or to try and access. And when we talk here about children, we're actually talking about under 18s, so that clearly covered quite a lot of online services. We covered the Children's Code, Age Appropriate Design Code in previous webinars, but it sets out 15 standards that the ICO would like organisations to comply with when they are providing online services that might be or are likely to be accessed by children. So we are now, what, 3 years on from that code coming in, and the ICO last month published its strategy for the next few years around the Children's Code and children's data. And this very much ties in, to say, with what's going on around the Online Safety Act. So OFCOM, which is a regulator for the Online Safety Act, is currently consulting on a number of pieces of guidance and codes of practice around that. And the ICO has entered into an MOU with Ofcom around how they will work together in terms of regulating online services that are maybe accessed by children. So some interesting stuff in terms of the ICO's priorities, things that they will be focusing on around investigations and enforcement, and well worth being aware of if you operate or provide any online services that may be accessed by children. So, for example, one of the priorities is around default privacy and geolocation settings. So emphasising the importance that for children's profiles and online services, they need to be private by default. So you might have stricter security settings than you might have for other users, and any geolocations tracking needs to be switched off by default. Likewise, the ICO will be focusing on profiling of children for targeted advertising. Rachel's talked about the payer consent model and the use of cookies. Again, the ICO is particularly interested around whether and how children's data is being used for targeted advertising in relation to services that they may access. And also, and again, this very much ties in with the Online Safety Act, is understanding how children's information is used in what are referred to as recommender systems. So these are the algorithms that will, when you're using, I don't know, you're accessing YouTube or Facebook or whatever, these are the systems that will recommend other content to you. And that may be harmful content, it may be things that touch upon the Online Safety Act, but there are also clearly privacy issues around that as well. The other area that the ICO is got to focus on is around the use of information relating to children who are under 13. So you'll be aware, I'm sure that in the UK, the so-called digital age of consent is 13. So that means that children who are aged 13 or over can consent to provide consent when using online services, but under that you would need to that age you need to have parental consent. And so the ICO is particularly interested in how services that may be accessed by children under the age of 13, how they are actually getting parental consent, how that's being managed, and whether they are using age assurance technology. So if you have a service which may be accessed by children under the age of 13 and you are relying upon consent for any of the processing that you carry out, you may want to be thinking about how you're actually managing that parental consent, how you ensure that it is indeed the parent that's giving that consent and not the child, and what age assurance technology you're using to try and manage that process. And the ISO, tying in with this MOU with OFCOM, it is also emphasising the importance of interacting with OFCOM and other regulators as well over the coming years. So for anyone, say, who provides services that may be accessed by under 18s, well worth keeping an eye on this one and just looking at what you're doing around the services you provide and how you use children's data. Next slide. Okay, so the next topic I'm going to cover is on facial recognition and biometric data. So you may have seen a couple of months ago that the Information Commissioner issued an enforcement notice against Circle. If we could just move on to the next slide, thank you. So this involved Circle Leisure, which was contracted to operate a number of leisure centres on behalf of various local authorities. And they had been using facial recognition technology and fingerprint technology to monitor employee attendance. There was a complaint to the ICO investigated, and they have issued enforcement notice ordering Circle to stop using these systems. We see quite a lot of this stuff. We see quite a lot of organisations who are approached by technology providers offering these systems, and that there are clearly some benefits to employers of using them in terms of being able to monitor employees, but it is something which has been a concern for a number of years, that there's an assumption that because these technologies and these products are on the market, that you can use them and they are lawful to use. And as this case shows, that's not always the case. So what did Circle do wrong here? Well, the ICO picked up a number of points. Firstly, there was no clear alternative to using the facial recognition technology or fingerprint technology to clock in and out. There were some very opaque statements within Circle's privacy notice about this, but which seemed to suggest that you could opt out of it, but actually there didn't seem to be an obvious way of doing that. So, there was no freely given consent by the individual to using that, no obvious way of actually doing something different. They didn't really explain to individuals how else they could track the entering and leaving the building. And the big issue here is that the Circle just didn't have a legal basis. They couldn't show what the legal basis was for using this technology. They couldn't show why it's necessary or why it's proportionate when there were other less intrusive measures that could be used. For example, ID cards or fobs or whatever that you could tap in and out. And so because they couldn't show that they had a legal basis for this, it's not enough just to say, well, you're an employer and you need to know when people are turning up or leaving work. They had no valid legal basis for that, and they didn't have any valid consent, because clearly the consent in this case wasn't freely given, even if there was wording there that they might have suggested people were somehow consenting to this. So a lesson learned there for Circle in terms of using this technology, and as a reminder for all of us about the fact that if you're looking to deploy biometric technology to track your employees or customers or anything like that, you need to very clearly work through how that is going to be done in a way that is lawful. So the Information Commissioner has, in parallel with the Circle notice, issued some updated guidance around biometric data, which we will cover on the next slide. So this guidance is some helpful reminders in here explaining what biometric data is. So that is things that relate to someone's physical or psychological behavioral characteristics. So it's not just someone's face or their fingerprints, but it could be a voice pattern. It could be the way that someone types, a whole load of things where you were actually able to identify or profile a person in terms of how they look or do things. And it's being used in a way which can identify that person as an individual. So if it is biometric data and it's used for the purposes of identification, then that is special category data under data protection law. It doesn't matter whether that information is hashed in some way in terms of how you're storing it. The point is that you're using their biometric data for the purposes of identification. And therefore, if you're using facial recognition technology or using fingerprint scanning or voice pattern recognition, things like that, then that will be processing of special category data. And that means that you don't just need an Article 6 condition for the processing, but you also need an Article 9 condition. And as you'll know, they are much stricter and much more limited. So there's a real challenge here in terms of actually working out how the use of technology like this is lawful. What is your legal basis for doing this, and why is it necessary? Because if you don't have a valid legal basis, then the only option remaining is to rely upon consent. And if you're relying upon consent, then you need to give people the choice. So if you are deploying it for access control within your building, but you can't find a legal basis for why that's necessary, then you would need to offer people the option of a non-biometric system if they wanted to use that. And as I said, the compliance obligations here will be on the entity that is deploying the system. So the employer, the service provider, whoever it is, will be the controller. It's not the technology service provider that you're using. They will simply be a processor to the extent they're doing anything in relation to this. So if we move on to the next slide, there's a helpful example of how you might work through this. So here, the example is around the gym chain that wants to replace swipe card access with facial recognition technology. They think that might enhance the customer experience by making it easier and quicker for people to access the gym. But that is processing biometric data. And so because given the objective is simply to make it easier for people to use the facilities and quicker, there is no legal basis under Article 9 for this, apart from explicit consent. And therefore, in order for that consent to be valid, they will need to very clearly explain what is being done, how the system works, how the data is being used, and then they will need to collect clear consent from the individuals. But they also need to provide an option for people who don't want to use that. So if you haven't consented, what is the default? What's the fallback for that? And in this case, the example is a PIN code that people could enter if they don't want to use the facial recognition technology. So a helpful use case, I think, just in terms of the issues to think about. What do you need to do? Well, starting point for all of this for me is vendor diligence. So the first step with this is if someone within your organization is looking to deploy technology by this, find out what the system is. How does it work? What data is collected? How is it stored? How is it used? How do you want to use it? What's the use case? Is there an option? Once you understand a bit more about the technology and how it works, you'll then want to identify a legal basis. So for some of you, there may be a legal basis under Article 9 that isn't consent, but in many cases that may not be the case. And as part of that, you really want to stress test the necessity and proportionality part of this. So is it really necessary to use this technology for that purpose? Doesn't mean there's absolutely no other way of doing it, but you need to be able to justify that it is necessary. If you don't have any other legal basis, then you will be relying upon consent. So you need to make sure that is presented as a genuine choice and you explain to people what the options are if they don't consent. What's the other way that they can do whatever it is that this technology is doing. Think about how you manage that. Transparency is key here. So providing people with lots of information on how the technology works, how it's being used, and also thinking about how you deal with data subject rights. So if you're relying upon consent, people have rights to object, people can make subject access requests. Are you comfortable that you can deal with all of these rights? Are you getting enough support from the vendor who's providing the technology to do that? And as with everything, as we say for pretty much every new technology, the really important thing here is to carry out a data protection impact assessment, because that is your key document for actually assessing what the risks are, assessing lawfulness, and documenting the steps you're taking to mitigate those risks is your homework if anyone ever challenges your approach to what you're doing. And if the ISO investigates, then the first thing they will ask you for is your DPIA showing how you assessed this before you actually implemented the system. So do carry out a DPIA, and if you are looking at this, or you use this technology just now and you're not sure about whether or not you do have a valid legal basis, then please do get in touch. We're working with a number of clients on this sort of technology at the moment and helping them to understand the risks and the lawfulness of it. Okay, I think now it's back to Rachel, who's going to talk about some other recent cases and enforcement.
Thanks, Martin. So yeah, firstly, to recent UK cases, which I think are quite useful. The first one looks at the concept of consent, which has been a bit of a theme in our update today. And I suppose we've maybe not spoken too much about consent since GDPR first came into force and all of the conversations that we're having then. But this first case, Join the Tribu Limited, is definitely a good example of showing that the ICO and the regulators are still interested in making sure that people are familiar with consent and using it properly. So firstly, as I say, Join the Tribu Limited. This was an appeal at the first tier tribunal against a monetary penalty notice. This is a quite unusual process or appeal to have been made, particularly for the ICO. So again, just wanted to cover that off. So what happened here? Well, between August 2019 and August 2020, Tribu, an operator of job search websites, sent 107 million direct marketing messages to around 400,000 people without their valid consent, and contrary to PECR. The statistics said that each individual would have received on average 244 emails in that time. So in the first instance, Tribu was saying that it sourced the data from its job source website to job search websites. It ran quite a few different websites under its brand. But the ICO's investigation initially found that it thought that some statements purporting to obtain consent were not specific or informed, and also that the privacy notice were a bit too general. So the ICO issued Tribu with an enforcement notice and also a monetary penalty notice for £130,000. Tribu then appealed on both counts. So the first tier tribunal dismissed the appeal, the first appeal against the monetary penalty notice, and the enforcement notice is going to be heard at a later date. So in this session, we're just going to focus on the monetary penalty notice. So the law at issue here, and the main question was around, did Tribu have valid consent to send the marketing that it sent? The applicable law, as you'll all know here, being under PECR and also the consent definition within UK GDPR. So when users signed up to Tribu's service, they were asked to give two consents. The first said, I agree with marketing activity, and the second said, I agree with third parties policy. Both of these were given as yes, no options, and actually the selections weren't pre-ticked. Individuals were asked to actively click that they consented. However, that wasn't really the case at issue here. So the FTT essentially confirmed that it agreed with the ICO and upheld the decision that both forms of those consents were invalid. So on that first consent, it essentially said that the consent for marketing activity was found to be too vague and non-specific to meet GDPR requirements for informed consent. The consent failed to detail what specific marketing activities would be conducted, who would carry them out, or whether these activities would include email. It also found that the privacy policy, which was hyperlinked in other places, but not from the first consent statement, didn't sufficiently clarify these points. And also, when you did find the privacy policy, the FTT and ICO both said that this actually added to the confusion, as it was then ambiguous about the separation of consent for job-related emails and marketing activities. Because wording in that policy implied that consent was a condition of registering for the site and actually the services that the site provided. They also found that the registration and welcome pages were unclear on whether registering for job emails was contingent on consenting to marketing. This was highlighted by the broad and non-specific nature of the term marketing activity used in the consent statement and the privacy policy. So as a result, in relation to that first consent, the court concluded that the consent obtained was neither informed nor specific. On the second form, interestingly, what the FTT found was that clicking on the third party's policy didn't constitute informed consent because it also failed to specify the purpose of the processing and the identity of the controller. The link didn't actually work either. The link was to a general privacy policy. The FTT essentially noted that the lack of clarity leads to confusion about the nature of the consent, with users potentially assuming it relates to receiving job opportunities from third parties rather than marketing activities. And essentially, it concluded that the consents given through these statements was not informed or specific, and therefore the recipient of the marketing emails had not validly consented to receive such communications. And on Farley, I'll just quickly rush over that one. So this is an interesting case where over 450 current and former police officers took action against their pension administrator for sending out pension statements containing personal details, including addresses and financial information, to out-of-date addresses. So the police officers brought an action for misuse of private information and also breaches of data protection regulations. Their claims for compensation were based on non-material damages on the basis of heads of claims such as anxiety, alarm, distress, and embarrassment. So firstly, it was important to note that the court immediately dismissed the claims in relation to those claimants who had not adduced evidence that their statement had actually been opened and read by someone other than the claimant. And however, they did allow the remaining 14 claims to proceed. So some takeaways from this, the judge said that to have a viable claim for misuse of private information or data protection laws, a claimant needs to show that they had a real prospect of demonstrating that the statement was opened and read by a third party. If the claimant had ultimately received their statement unopened, or if it had been returned unopened, they could not have a claim. That was on the basis that the privacy of that claimant had not been compromised and they could not advance a claim on that basis that it had been in danger or at risk. The court wasn't interested in that. It was only interested in concrete evidence that there was actually a true opening of their statement. Moving on to the EU, and just quickly run through this. Essentially, although these cases aren't binding, they're often helpful in helping us interpret GDPR principles. So one recent German case that went through the courts helped us to clarify the relevancy of human error and non-material damage thresholds. Similarly to the Farley case, in distress, essentially saying that distress alone, in terms of fear of data protection rights being infringed, is not enough to have a claim for compensation under GDPR. You have to show that there has been a breach, there has been actual real damage, and that there's also a causal link. On liability for human error, the ECJ found that the controller cannot exempt itself from liability by referring to the misconduct of a person under its authority. Essentially, it's the controller that is responsible for the actions of its employees. And actually, one interesting point that the court made on that was it's the controller's responsibility to make sure that its employees are all adequately trained properly. So if that training then hasn't been in place and it's resulted in a data breach, then of course, again, the liability is attributable to the controller. And just finally on this, the case also asked whether some of the criteria under Article 83 in relation to assessing fines should also be used or could also be used for assessing damages under Article 82. Essentially, the court disagreed and said no. They said the two different provisions have different objectives. Article 82, which is on damages, doesn't justify punitive damages, compensation, does not justify punitive damages, but serves exclusively to provide financial compensation for damage suffered. However, when assessing damages in terms of fines, of course, they can be punitive to reflect the nature and severity of the breach. And I'll pass over to Martin to do a last cyber update.
Thanks, Rachel. Yeah, so I'm going to talk about a couple of bits of updated guidance and consultations that's ongoing in relation to cyber. So the first of these was earlier this year, where the government was consulting on a new, what they refer to as a cyber governance code. And this is a voluntary code which would be aimed at directors and business leaders to help them better understand cyber risk and what they should be doing in relation to that and why. So quite an interesting document. It's designed for all organizations, not just those of a particular size. And it's been co-designed with auditors, non-executive directors, chief information security officers, and academics and others to provide some pragmatic and helpful guidance to business leaders who may otherwise not necessarily be fully familiar with the issues or how they should approach them and discharge their duties as directors. So it's built around five principles. They're there on the screen, but it's looking at things like risk management, it's looking at cyber strategy, responsibility for people and how you manage that, incident planning and response, and then the use of assurance and oversight as part of the way in which you can mitigate a lot of these risks and understanding how the role that plays in it. So quite an interesting document. I say it was out for call for use early in the year, and we're expecting the finalised version to be available soon. The government referenced it at the Cyber UK conference the other week. Though obviously we're in a bit of a hiatus in terms of publication of new guidance. Moving on to the next slide. So these are two calls for views which were published on the 15th of May. So the position with these is that though that consultation will continue, notwithstanding the election has been now being called, but we won't see any result or response to that until there's new government in place. So I think these both run until about the middle of June. So if you are interested in them, you can continue to provide feedback. But two other bits. So this is part of a wider framework the government's looking to put in place around codes of practice and guidance for cyber risk. The first of these is dealing with cybersecurity in relation to AI. And this is building on work that the National Cybersecurity Centre and the US CISA and other international bodies did last year around some guidance for the secure development of AI. And it sets out 12 principles. And this is not just about developers of AI systems, but it also covers operators. What's referred to in the code of practice as data controllers, so that's not necessarily what we understand a controller to be for the purposes of data protection law, and also users as well. So it's made up of a number of bits that cover various parts of the AI life cycle. It's a voluntary code at the moment, but the government's intention, or the outgoing government's intention, was that the finalised version of that would be submitted to an international body like the ETSI to become the baseline as a new global or international standard. So quite interesting in terms of seeing where that goes, and well worth looking at those principles and familiarising yourself with them if you are looking to develop or deploy or use AI systems. The other part of this is around software development. So this is a code of practice that's aimed at software vendors. And it again sets out a number of principles and provisions which cover various themes in terms of the development of software, ensuring that is done in a way that is safe and secure and kept up to date. So it covers design and development, covers the build environment security, it covers deployment and maintenance. So particularly this point around the fact that software is inherently, you need to keep it up to date. Bugs will arise, issues will develop. And so throughout the product lifecycle, it's important that the vendor has in place a clear policy and approach to how they are maintaining security. So that's a key part of it. And then also ensuring that there is a clear way for communicating with customers and users of that software to help them understand the risks that are there and to deal with incident management. So again, that is relevant if you're a business that develops software, but also if you are procuring software from a third party, then it may be something that we might expect to see referenced in contracts when we're looking at supplier diligence to provide some reassurance that the developer of that software is paying proper attention to cyber risk and helping you to manage the risk to your organization. Final thing I'm going to talk about on the last slide here, just a flag that the National Cybersecurity Centre has been doing, publishing some guidance around business email compromise. So this is where emails are sent or used in a way to try and get people to publish or disclose or do things or transfer money and basically committing fraud. So there's a number of stories in this around the use of deep fakes and Gen AI. There's a story about a finance director who I think was tricked on a Teams call where there were virtual avatars on that call pretending to be people within the organization, using generative AI to create that video and to create the voice to persuade them to actually transfer money. So just a couple of recommendations around this. The way that those systems work is that they consume your digital footprint. So if you are speaking in a webinar such as this one, or on social media and doing things like that, then the more information that's out there about you, the easier it is for someone to create a deep fake or impersonate you in some way, because it just takes a few words or a few bits of video to actually enable someone to create someone that looks and sounds like you and use that in relation to potential fraud. Also important to help make sure your staff are aware of how to spot phishing emails. It is still the primary cause of any cyber attack. It generally always starts with a phishing email that actually gets the attacker into your organization. And looking at things like applying two-step verification. So, even if it's to transfer funds, well, or if you've got some sort of code word or password or something else you can use to verify that process, or a second person has to approve it, even if it appears to be coming from someone who is senior within the organization. Applying this approach of minimal trust in terms of how you actually approve decisions and ensuring that you are having some multiple steps in there. So just for guidance, I say it is something that we are seeing more and more, and there's lots of stories that are being published every week, it seems, about organizations that are being subject to cyber attacks or fraud that is perpetrated through business email compromise or these sort of deep fake attacks, and well worth looking at in terms of your own organization's resilience and steps you're taking to mitigate that. That's just gone past Q2, so we have probably a couple of minutes for some questions. Rachel, just one point for you. I think in your slides on the SCCs, you referenced 21st of March 2023, but just that's 21st of March 2024 for stopping using the old SCCs, isn't it?
Yes, correct.
Yes.
Thank you.
Yeah, so that date has just passed in the last couple of months. So yeah, you will want to be getting on with that if you're still using the old SCCs. We've had a question about privacy notices and transfers to the EU or EA, and whether, given that those countries are covered by an adequacy decision, you need to explain that in your privacy notice. So the answer to that is yes. So the requirement is that you list any transfers to third countries, so anywhere outside the UK. It doesn't matter that you're relying upon an adequacy agreement. You still need to disclose that within your privacy notice. But what you would say in relation to that is that you're making a transfer pursuant to an adequacy finding, so you don't need to reference standard contractual clauses or the IDTA or whatever it is that you are relying upon that. Just looking down to see if we've had anything else. And Rachel, a quick question just for you, maybe around the Tribu decision. Is it just in terms of lesson learned? I suppose a lot of this was to do with third-party mailing, and I suppose is getting data from data brokers now dead? Given that the issues that were flagged, what diligence can you do if you are looking to do that?
It's absolutely more difficult as well, because the ICO essentially expects you to do a lot of due diligence, and the decisions that we've seen come through is that there's not really any excuse to be undertaking marketing where there's not been valid consent collected. So it's then not really a defence to say, oh, I collected it from a third party. The onus is on, every party within that chain. And I think, it can still be used, but it's just means due diligence is extremely important if you're ever taking information from other third parties, particularly ones that you don't know. I mean, there's definitely various steps that you can take to provide comfort, but it is quite difficult, and you would be wanting to see quite a lot of information around accuracy and making sure that those consents are absolutely in place. And I suppose one other point to touch on is, reputationally, it can be quite important to make sure that all of these steps are taken as well, because if it's your organisation that is ultimately sending out the marketing emails, it's going to be your name and branding all over it. And, if the consents haven't been validly obtained further down in the supply chain, it's your organisation that data subjects will associate with the spam emails or, make complaints to the ICO about. So there's quite a lot to consider, albeit there might be a contractual claim if you did contract with a third party broker to provide you with data, and within that you say, you've validly collected information, but definitely taking practical steps to make sure that the consents are valid is very important. And essentially, in practice, it is very difficult to get that complete comfort and clarity. So yeah, it's difficult. We're definitely seeing it less and less. It's definitely less attractive.
Yeah, and that reputational point you make I think is absolutely key, because it is the entity that is relying upon or sending out those communications. It is the one that will be receive the reputational damage, and the one that will be subject to the investigation from the Information Commissioner or regulatory action. So I think that's a good point to end on. So I think all that's left to say is look forward to seeing you for our next update in the autumn. Thanks.